everybody can give it a My name's Matt, and I'm a patent attorney.
Yes, because we've read the things.
I'll press it later.
So, yeah. My name's Matt, I'm a patent attorney. Have you got this in the back? Yeah, good. All right. I've never followed a Mexican way before as a speaker, so that's new for me. As Simon said, so I'm going to talk about ideation and I'm going to talk about intellectual property. Now, this all comes from my own knowledge, my own experience. So in relation to ideation, then I don't claim to be an expert, but I've seen a lot of ideas. I would also say this isn't legal advice. If you need support for your business, don't use this as your legal advice. Get your own legal advice. There is my disclaimer. Right. So what am I going to talk about? The first thing is some thoughts on what I think makes for a good idea. And then the second part is going to be a whistle-stop tour, because we've got 15 minutes, through intellectual property rights. Okay, so firstly, what do I think makes a good idea? And in my experience, people come up with two kinds of ideas. The first kind is as a user. So it's I really want to launch that product. I would definitely buy it. Why isn't it there? I want to do this. And then the second kind of ideas that I see are as an industry insider. So we could make more money if we did it like this. If we sold the product like this, if we used these channels, if we operated in this way. And I have tended to see much more success with the second approach. Often you find that users they don't have the experience in the industry. They may not necessarily understand why these products aren't on the market. It may not be that nobody wants it. Maybe not enough people want it. Maybe it's too difficult to make, too difficult to sell, those kinds of things. So I would recommend ideas of the second kind, where you've got some kind of industry experience, where it's an industry that you know. That said, that doesn't mean that you shouldn't go for a disruptive idea, but you need to bear in mind that there are things about that industry that you may not know, and you've got to be prepared to learn. One particular kind of business that I really like is the kind that finds a way to sell something that nobody wants. And my example of this is I thought about lastminute.com. So lastminute.com, before there was lastminute.com, you had a load of hotels, you had a load of airlines, and they had seats on planes, they had hotel rooms that they thought they weren't going to sell. They thought nobody wanted them because they were for tomorrow. And then suddenly what you do is you turn it around and you say, well, how about I find all the people that want something tomorrow and say, here's all the things you can do tomorrow. Now that to me, I think is genius. And it's one of those situations where you're finding someone else's waste and then selling it. If you can find something like that, that is a great business opportunity. I think the other thing that I've got to say about ideas is it's really important to remember that there's not actually that much value in the idea itself. Thomas Edison famously said that invention is 1% inspiration, 99% perspiration, and he knew a bit about inventions. Even the very best idea needs to be implemented well, and I have seen a lot of good ideas killed by bad businesses around them. Another question that people ask is, how unique does my idea need to be? People worry about this. Does it need to be completely unique? And what I think is that oftentimes you have a big idea, and that may not be unique, but actually what you can do is put the uniqueness in the way that you implement it. And I was thinking, for example, Tesla didn't invent the electric car. Yeah? But what they did do was they implemented it in a way that people actually wanted to buy them. So you can think about it in those kinds of terms. Even if your big idea isn't new, the implementation is good. So you can make smaller, protectable innovations around your big idea, and that can make you a business with strong intellectual property. So what is intellectual property? I've said here, these are my notes, by the way, I'm not just checking my email. So, intellectual property, it's the ideas, the creations, the information that are in the business and that can be protected with legal rights. Oftentimes, the underlying creations are referred to as intellectual assets, and the legal rights are the intellectual property rights. Now, one of the questions that you might be asking is why protect intellectual property? Why do that? So, as business founders, your business succeeds because of your creativity, your knowledge, and your hard work. But at some point, you want to end up on a beach with a big bag of money, sipping margaritas. So what the intellectual property rights do is they allow you to convert your creativity into legal assets that can be sold on with your business. That's the point. It's also the case that when people invest in your business, it gives them some reassurance to know that if you mess it all up, there'll still be some assets there that can be taken as bare bones of the business and be given to someone else that might make it successful. Right, now I'm going to go through some kinds of intellectual property rights, and we don't have time to go through this in depth, but what I'm trying to do is to tell you the things that I think are the most important for you to know about these kinds of rights. I'm just going to have a sip of water. Right, so let's start with copyright. So copyright is a right that protects, and this is a formal definition, original, literary, dramatic, artistic, other works. It protects things like software, photographs, protects website content, protects music, of course, films. Now, in this sense, original means that it's not been copied from someone else. It's your own creation. That's required for copyright purposes. What it doesn't do is it doesn't protect concepts. It doesn't protect ideas. It just protects the way that they are expressed. And to illustrate this, does anybody remember the Da Vinci Code? Excellent, at least one person does. So Da Vinci Code was a book written by Dan Brown, and a movie subsequently. And in it, it had this idea that Mary Magdalene had a baby, the theme in there. Sorry, spoiler alert for anybody who hasn't read it. Dan Brown was sued by a couple of other authors who said, well, we wrote a book much earlier that had this same idea in it, and so you've infringed our copyright. And the court said, no. The court said no, because they don't have any copyright in that idea. What they've got is they've got copyright in the words that they wrote. If Dan Brown had taken a paragraph from their book, maybe even a sentence, an exact sentence from their book, that might have been a copyright infringement. But using the same idea is not an infringement of copyright, and that's why that failed. Interestingly, they were with the same publishing house. So I wonder how much of that was a real court case and how much of it was just about getting in the press. So a good thing about copyright is it arises automatically, so it's free. When you create a work, then it's protected from the point you created it. But it only protects against copying. Someone has got to have seen your work and copied it and had access to it. If they come up with it independently, without you, it's not an infringement of your copyright. Important things to remember is about keeping good records of who created what and when. That affects the term of copyright. And also, I think what's really important, think about ownership. When you're having things created for you, so you're having artwork, graphic design, websites, anything like that, look at the contract that you have with the person that's doing that and understand who is going to own the copyright in that at the end of it. Because oftentimes website designers, for example, will retain the copyright in the website that they create because they want to continue, they want you to continue using the hosting service, for example. Right, let's talk a bit about trademarks. So trademarks protect brands. Brands might be words, might be logos, for example. There can be other things. You can have colours and sounds as trademarks. And the legal definition is a sign capable of distinguishing the goods or services of one undertaking from those of other undertakings. So it's a distinctive sign. It tells you often called a badge of origin. It tells you where that's coming from, where that product or service is coming from. So that means that you can't register cheese for a cheese shop. You can't register very good cheese for a cheese shop because other cheese shops need to be able to use the common terms in the trade to talk about their product. So it can't be descriptive of what you're doing. Good trademarks that I like. Uber's good, doesn't tell you anything about what they do. Ocado, Netflix, they're all good because they don't describe the product or service that they're providing. The other thing about trademarks is they must not conflict with existing registrations for similar goods or services. So you can't register Coca-Cola for soft drinks. You probably can't register Coca-Cola for anything, so famous mark. But you can have the same trademark for different kinds of goods and services, different industries. So if I say to you Lotus, you think immediately, anybody? Cars, right. Cigarettes. Oh, there you go. I didn't have that one. That's true. There's a cigarette. Yeah. So Lotus is also a paper product brand. You get napkins and things, and you used to. I don't know whether you still do. You used to get software and spreadsheets under Lotus as well. Yeah. So you can see the same trademark can be used in different industries. So if you come up with something and it's used in a very, very different industry, then that's potentially not a problem. Trademarks, once you've registered them, that's for 10 years and they can be renewed forever. Actually, one thing that's worth saying, your brand and the protection around it, the trademark registration, will probably end up being your most valuable piece of property. It certainly is for any large business. A little bit about design rights. So you've got design rights that protect the appearance of a product, shape, colour, ornamentation, things like that, but they don't protect function. Designs have to be new and of individual character, but that's not a very difficult test to meet. There is unregistered design right, that's like copyright. When you create a design, you've got some automatic protection against copying. You can also register a design. That gives you stronger protection. You don't have to show copying. You can just show you've got a registration and someone's infringed it by providing a product that looks just the same. What people get attracted to registered designs because they're relatively cheap to do, but be careful that you understand exactly what it protects and doesn't affect the function of your product. Looking at patents. So patents protect technology. Now, you don't have to be a rocket scientist. It doesn't have to be the cleverest technology in the world. There are patents out there for paper clips. It could be something relatively simple, but it's how something works, what it does, how things operate. A really important thing to know, if you want to get a patent for a product that you intend to launch or a process that you're going to carry out, then that product must be absolutely new. That means never heard of anywhere in the world ever before. And that means that you have to keep it secret until the point when you file the patent application. That's probably one of the most important things to understand around IP at this point. Not only does it need to be new, it needs to involve what they call an inventive step. So that means it's got to be a bit different to what's gone before. It needs to be more than just a routine development. I would always get advice on this. You may think, this product's new. Yeah, I've never seen anything like this before at all. But is it worthy of a patent? I think the question has got to be, if it's new and you would like to monopolise it, then get some advice and see whether you can get a patent. Don't disregard that. Think, I can't believe I get a patent for that. Get patents for incredible things with the right patent. There are some things that you might consider to be technology that are going to be excluded from patent protection. It is difficult to protect the commercial model of a website with patents. If you've got software, something that's implemented in software, it needs what they call legally an additional technical effect. So that could be something like the software that runs a car engine, something like that, and it's doing something in a field that isn't excluded. Again, get advice. If you think you want to monopolise the technology that you've created, get some advice about it. When you file a patent application, you have to explain in technical detail how the invention works. And that patent application will be published, and it'll be published even if you don't get a granted patent. So what that means is you can't keep an invention secret and patent it. If this is something that you think you need to keep secret, then you've got to make a decision between the two. There are some other things that I would call intellectual assets that aren't necessarily formal IP rights, but that are worth thinking about in terms of the value of your business and keeping track of. So there's confidential information. The classic, obviously, is the formula for Coca-Cola, which is supposed to be a secret. But the question there with any business, if you're going to rely on keeping things secret as an intellectual property position, is can you? If you've got to tell other people how to make your product, if you're going to franchise, if you're going to have other business, you've got a factory that's going to make it, are you actually going to be able to keep that secret? Because once that secret's out, then you don't have any protection anymore. I'll put here as well, your employees, just if you think about intellectual assets, the people that you have in your business, so make sure that you've got good employment contracts, that you understand how to look after those people and how to protect the business from them running away, perhaps, with all the knowledge. I put data. So data, I think, is increasing. If you look at the largest companies, their biggest assets are potentially what they know about their customers and what they know about their products. The Amazons, the Googles, Metas, that's where all the value is. So think about what you know and think about keeping track. And take the steps that you can to protect them as much as you can. So when should you be considering intellectual property protection? And I would say right at the start. An important thing, choose a brand that you can actually register, because what happens is you come up with these great names and you get emotionally attached to them. You think, well, I'll check this out and we'll change it. But actually, that never really happens. So I would put out 5, go and see your trademark attorney, and then stick to one that you can actually protect. And also think about patenting before you're going to have to make an invention public. Do some research on potential competitors and what their intellectual property rights might be, problems. And that's the time to go and talk to an intellectual property solicitor, a patent and trademark attorney, and get some advice. So the final thing that I was asking, that I thought was a question that I should answer, is it expensive? Which I think it can be. It can be expensive. You can certainly spend thousands of pounds on intellectual property protection and advice, and I would say you probably should. You can spend tens of thousands. In some cases, you spend hundreds of thousands over a period of time. But I think all the time you've got to remember that in doing that, you're investing in your business, because those are the rights that are going to make it into a saleable business in the end. So get it in your business plan and treat it as an investment. Thank you.
Yeah, it's wonderful. Absolutely perfect. I'm going to start the questions.
Okay.
I just partly because it's leading on from what we were talking about in the pitching competition with Dave when we mentioned people are scared of revealing their ideas.
Mm-hmm.
And it's something we say to them, well, unless it's something to be patentable, then really you should be trying to communicate your ideas with customers, but don't give away the secrets of what you're trying to do.
Yeah.
Is that the sort of advice as an IP professional that we're following the right path with?
Yeah, well, there's a balance there, isn't there, between getting a sense check, getting some market feedback. One of the ways of doing it, so let's say you've got a product that's going to be fantastic.
Yeah.
Then one of the ways to talk about it is to talk about the benefits rather than the features. So talk about the benefits. Say, actually, I've got a car that can go 1,000,000 miles an hour and it runs on water. Are you interested? Okay. That's not going to be a problem, because if you're going to get a patent for that, you're going to have to be able to explain how a water engine works, and that's going to be the key to it. So you can talk in those kinds of terms.
And I think that very much fits in with the way we're going to be talking this afternoon about it's not trying to give away how something works.
Sorry.
Oh, sorry. Can't hear me? Okay, so one of the things we're going to be talking about this afternoon is about trying to get an idea out there for people to give feedback, to be able to validate the idea. So what I'm hearing from you, Matthew, is that we talk about the problems it solves, and what it does for customers, rather than this is how it works and this is the ins and outs.
Yes.
Yeah, brilliant.
Yes. So definitely not. This is how it works. If you can get in the patent, but you can get that patent application on file.
Sure. Okay. Questions from the room, right? Over to you.
Thank you. I was just going to ask, the patent, is it only valid in the country that you're taking the patent, or is it valid worldwide?
Excellent question. So yeah, patents are national rights. You can file in one country, and then so there's no such thing as a world patent. But you can certainly file in one country, and then file in other countries within 1 year. There are ways of doing that to extend that to up to 2.5 years with what they call a patent cooperation treaty application, which will cover a lot of countries. But ultimately, you're going to want patents in the most important countries. What I would say is you don't end up patenting the world. People do, even the largest corporations will not go very expensive, because once you've knocked out, say, the US, you can get a European patent, or cover it well, you can cover European. Once you've done that, China, Japan, after that, it's a law of diminishing returns in terms of the spend versus what matters, because you've dominated the market.
So if someone from, say, a small country copyright, you can't sue them.
Yeah, correct. So if it's a small country and someone launches that product in the small country, you don't have any patent rights there, then you can't sue them. But if that country is so small, do you actually care in the global market? No offense to anybody from a small country.
And time for one more question, lady.
Good afternoon. I did trademark my brand, and I prepare myself to register the design of my product.
Mm-hmm.
What they didn't tell me was that by registering the design, I'm not the function of my product is protected.
Isn't protected.
Yes.
Correct.
So it's not protected.
Correct.
So I learned that with you today.
Okay.
And so I was wondering, okay, my objective was to protect the design, also the function of the product.
Yeah.
So what can I do to protect the function of the product, as the design registration is not enough for product? What's the option?
Is your product on the market?
No, it's not on the market yet.
Has your registered design been published? Has it been registered?
No, I'm put together everything they asked me to register the design, and right now, before we move forward, I want to know what can I do to protect also the.
So if you want to protect the function, then that's patents.
Okay.
And you should. I would go and see a patent attorney. Okay, sorry.
Okay.
And Matt, we can have to finish up this question.
Okay, fine. So yeah, you want to protect the function, that's patents. Go and talk to a patent attorney. If you want to get free advice, you can go to the Chartered Institute of Patent Attorneys, and they do clinics, and you'll get advice from a patent attorney there, at least as an initial option, or find someone.
You have a business card. I don't want to.
I'm not in practice at the minute, so I'm not advice, sorry.
Matt, thank you very, very much for that.
Thank you.